Now, was the frisk legal? Did police violate Mr. Robinson's right to be secure from unreasonable searches? Mr. Robinson thought so. During his prosecution, Robinson filed a motion to suppress the evidence recovered as a result of the frisk, contending that the frisk violated his Fourth Amendment rights. The officers, he argued, had no articulable facts demonstrating that he was dangerous since, as far as the officers knew, the state could have issued him a permit to carry a concealed firearm. Now, after the district court denied the motion to suppress, Robertson pleaded guilty to the illegal possession of a firearm, reserving the right to appeal the denial of his motion to suppress. Now, Mr. Robinson has a very interesting point. Why should someone being in possession of a firearm lead to an assumption of dangerousness? After all, for all the officer knew, Mr. Robinson could have been a legal concealed carrier. He might even have had a carry permit. How does that establish reasonable suspicion that a crime was being committed? When that didn't work at trial, Mr. Robinson tried again on appeal. On appeal, Robertson contends again that the information that police received from the tip describes seemingly innocent conduct and that his conduct at the time of the traffic stop also provided no basis for officers to reach the conclusion that he was dangerous. He argues under the logic of the district court, in any state where carrying a firearm is perfectly legal, every citizen could be dangerous and subject to a Terry frisk and pat-down. Mr. Robinson's argument on appeal gets even better. None of his conduct would lead a reasonable person to believe Mr. Robinson was dangerous unless you assume everyone with a gun is automatically a danger to society. And if everyone who legally carries a firearm is automatically subject to a Terry stop from the case Terry versus Ohio, then merely exercising your right protected under the Second Amendment could be considered reasonable cause for a stop and frisk. There's another point that I find important, but didn't see in the court opinion. The tip was anonymous. Now, under the Sixth Amendment, you have a right to confront your accuser. It reads, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. If the reasonable assumption that the police used to search Mr. Robinson was based on an anonymous tip, how can he confront his accuser? If so, Mr. Robinson cannot confront the person who accused him of carrying a loaded weapon in court. Now, how can that be used for reasonable suspicion? After all, isn't an anonymous tip hearsay? For all the court may know, the accuser has a personal interest in seeing Mr. Robinson harassed, regardless of his guilt. We reject Robinson's argument and affirm, concluding that an officer who makes a lawful traffic stop and who has a reasonable suspicion that one of the automobile's occupants is armed may frisk that individual for the officer's protection and the safety of everyone on the scene. If the reasonable suspicion of the possession of a firearm is sufficient for an officer to frisk a suspect, what about the civilian? After all, there is more than a reasonable suspicion that the law enforcement officer is armed. Does that give cause for the civilian to frisk the officer for his or her safety? If only one party is armed, then only one party is a threat to the safety of everyone. The court goes on to say, the Fourth Amendment does not require police officers to take unnecessary risks in the performance of their duties. Well, the Fourth Amendment says no such thing. I agree that police officers should not have to take unreasonable risks in the performance of their duties, but those duties include following the supreme law of the land. That is why their oath of office requires they swear or affirm to support the Constitution of the United States. Continuing, it is also inconsequential that the passenger may have had a permit to carry the concealed firearm. The danger justifying a protective frisk arises from the combination of a forced police encounter and the presence of a weapon, not from any illegality of the weapon's possession. Which gets to the root of the problem. If the danger comes from the presence of a weapon during a forced police encounter, regardless of whether or not it's illegal, why does it matter which party holds the firearm? If police were as pure as the wind-driven snow, well, then it would be reasonable for the threat to be one-sided. Then again, that would mitigate the need for police to have internal affairs divisions and for other law enforcement entities to have inspectors general. Now, while I'm sure the vast majority of law enforcement officers are just trying to do their job, there's plenty of evidence that some of those same officers have abused their positions. Not to mention that some of those encounters have led to the assault and battery of the civilian, all while the civilian is defenseless before a government official. Isn't that why we have a Second Amendment? To make sure we the people aren't defenseless against a potentially hostile government?